I'm the director of the Liberty Project here at ASU Law. I'm a second-year student, and I'm so very pleased to see so many of you out there today. I'd like to introduce our panelists today. To my immediate left is Gloria Feldt. Gloria is co-founder and president of Take the Lead, the new women's leadership movement to prepare, develop, inspire, and propel women to take their fair and equal share of leadership positions across all sectors by 2025. She is a best-selling author, an acclaimed expert on women, power, and authentic leadership, and an inspiring keynote speaker. Gloria is a former president and CEO of both Planned Parenthood Federation of America and our local Planned Parenthood affiliate. She was named by Vanity Fair as one of America's top 200 women leaders, legends, and trailblazers, and Glamour's Woman of the Year. Author of 4 books, Gloria teaches women power and leadership here at ASU. She has been widely quoted and published in media, including the New York Times, Washington Post, USA Today, Politico, Salon, The Daily Beast, and magazines including More, Glamour, Elle, and Ms. She has appeared extensively on television, including CNN, MSNBC, The Today Show, Good Morning America, and The Daily Show. To my farther left is Bryan Howard. Bryan joined Planned Parenthood in 1984, originally in Chicago, Illinois. In 1997, Bryan was appointed president of Planned Parenthood of Central and Northern Arizona, the predecessor to today's Planned Parenthood Arizona. He is also president of Planned Parenthood Advocates of Arizona, the statewide voter and candidate education organization. Bryan has and continues to serve on numerous national, regional, and local boards and commissions. He is currently a board member and officer of RH Reality Check, and he serves on the Chancellor's Advisory Council of the Maricopa Community Colleges. He previously served on the board of Planned Parenthood Federation of America, the Washington, D.C. Reproductive Health Technologies Project, Equality Arizona, and the Howard Brown Health Center in Chicago. To my immediate right is Larry Rosenfeld. Larry is a practicing lawyer and partner at Squire Sanders here in Phoenix. Larry has almost 40 years of experience in the areas of employment law, litigation, health law, and administrative law. He is a fellow of the College of Labor and Employment Lawyers and a member of numerous professional organizations, including the employment law, litigation, and health law sections of the American Bar Association. He has represented Planned Parenthood Arizona as its principal outside counsel for more than 35 years and has litigated a substantial number of cases seeking to invalidate state laws that have attempted to unconstitutionally interfere with reproductive rights. And our moderator today, to my far right, is Leon Silver. Leon is a business and real estate trial lawyer in Polsinelli's commercial litigation practice and a leader of Polsinelli's retail and hospitality industry team. He is also the founder of the Liberty Project, where he serves as our fearless leader, and I thank him for that. Leon is a frequent speaker, seminar participant, and author on topics ranging from advanced trial advocacy to cybersecurity to abortion rights. A former high school teacher and career-long advocate for women, Leon has spent the last 25 years protecting and promoting freedom, education, and empowerment as a board member, board chair, advocate, fundraiser, public speaker, and volunteer lawyer on behalf of Planned Parenthood. He has been recognized by Planned Parenthood with its highest award, the Peggy Goldwater Award, and currently serves as co-chair of the trustees. This past February, the YWCA of Metropolitan Phoenix recognized Leon at its annual Tribute to Leadership dinner as its advocacy leader. Please join me in welcoming our panelists today.
All right, so what we're going to do today is we're going to have basically a conversation. This is we call this an Arthur Miller style seminar. And Arthur Miller was here just 10 days ago doing a seminar. There'll be a significant difference between this and that. When Mr. Miller did the seminar and had the judges and law professors and famous lawyers up there, he as the moderator was the most knowledgeable authority in the room. We don't have that problem today. So we're going to talk about this is the third in what we have a 3-part series on the history and the future of abortion rights. 2 years ago in this room we had a panel that consisted of Sherry Finkbein, her daughter Christy Atwell, and our friend Stan Lubin. And that panel talked about what life was like before Roe v. Wade. And for those of you who weren't there or don't know, Sherry Finkbein became internationally famous, as she said, for being the only Jew excommunicated by the Pope, but more so because she was the local romper room teacher in Phoenix in 1962. She had taken thalidomide during a pregnancy and realized that she needed to have an abortion because what had happened to her fetus. And she went public for the purpose of educating other women about the thalidomide problem, and the backlash came when everyone found out she wanted to have an abortion. She was fired. She ended up having to go out of the country to have the abortion. She presented during our panel discussion about her experiences, and then was followed by her daughter, who was born 2 years later, who never would have had that opportunity had Sherry not had the abortion. Stan Lubin talked about his experience, again, before Roe versus Wade, with a high school girlfriend, a former girlfriend. He had moved away, who died in New York City as the result of a botched back alley abortion. Last year we had Larry Hammond and Loretta Ross, and Larry Hammond was a clerk on the Supreme Court when the Roe decision was made, and he was actually very instrumental in some of the politics that went on with that. And he talked about how current events may or may not have affected the decision. And then Loretta Ross, who's a community activist and long time, talked about how the Roe decision affected life for women in the community. So it was kind of a two-sided coin, I guess would be a metaphor for that. So today we're going to talk about, briefly we're going to talk about what's happened since Roe v. Wade, but more importantly we're going to talk about the kinds of challenges that are going on today and what kind of things we expect will happen in the future and what we ought to be able to do about it. I got to tell you, I mean, this panel that we have is just phenomenal. This, I think, marks the first time that Gloria and Bryan have served on a panel together. And that also marks the entire history. All three of them mark the entire history of my involvement with Planned Parenthood. My first involvement was in 1989. I met Gloria when the Webster decision came out, and then I worked on the Attorneys Action Council starting in 1990, and Larry Rosenfeld was the lawyer advisor for that. The Attorneys Action Council ultimately morphed into what is now the Liberty Project. And when Gloria moved on to New York to run the Federation, Bryan came in, took over, met me, and was horrified. But we worked it out. I mean, yeah, trust me. Okay, so let's talk very briefly about Roe v. Wade. 1973 Supreme Court decision. Now, if you go way back into the history, you'll find that most states had laws outlawing abortion, but the genesis of those laws was to protect the health of the mother, because the medical process, when these statutes were enacted, the practices were so bad that women were suffering these terrible consequences. That then developed over time into this more moral question about whether abortion is right or wrong. So the Supreme Court was facing a Texas law and others that outlawed abortion, and except in cases of rape or incest. And the court struck down the law. The court actually decided Roe v. Wade 7-2. And the essential holding of Roe versus Wade was that the right to choose to terminate a pregnancy is a fundamental right and is therefore subject to strict scrutiny. So all of those law students in here who have taken constitutional law know that strict scrutiny is the highest standard, and that at least by the time of Roe and for several years after, no law ever made it past the Supreme Court if it was being reviewed under a strict scrutiny analysis. And the analysis was, the strict scrutiny means that a law has to be narrowly tailored to promote a compelling state interest in order to overcome the individual right that's being affected. In Roe v. Wade, the difficulty, the unusual part of Roe v. Wade is that the compelling interest, there are actually two compelling interests that the state was wanting to regulate, and those two interests competed. There was the compelling interest of the state in preserving and protecting the health of the mother, and there was the compelling interest of the state, or the interest of the state, to promote the viability of the fetus and the fetus's right to survive. And what the court did in that decision, Justice Blackmun's decision, was they came up with this trimester analysis. And so in the first trimester, the woman had the absolute right to make the decision for herself. In the second trimester, the court ruled that a woman could, the state could regulate the decision, but only for the purpose of preserving maternal health. And in the third trimester, the court, which was then deemed to be the point of viability, which then was 28 weeks, the court ruled that then states were free to regulate and to enact laws that promoted carrying the child to term. So that's the background upon which we go forward. And one of the, and I guess and what we're going to do today is we're going to have I'm going to stop talking so much, and we're going to have a conversation with these folks up here about a little bit about what's happened since, and very much about what's happening now. And I want to start that conversation by asking Gloria Feldt to talk to you about, well, let me ask it this way. We all celebrate Roe v. Wade. Was Roe v. Wade a good decision?
Thank you, Leon. And I want to say, let's all give a round of applause for these three men who have been such great leaders for women and reproductive rights. Putting on this hat, which I don't wear that often these days, is it gives me a chance to reflect on some of those big questions. I'm going to just sum it up quickly, and then I'll do some. What?
Can they hear me?
Can you hear me back
Can you
there?
hear?
Can you hear me?
Is the microphone working?
Closer? How's this? Can you hear me?
Better.
It's good? Okay, all right, great, thank you. So I'll do a quick sum up, and then I want to try to give you some sort of yeses and nos in answer to that question. Basically, I would say Ruth Bader Ginsburg was right, that Roe should have been decided on women's rights and equal protection basis as opposed to privacy, that Sandra Day O'Connor was very wrong, and I'm sure you all will get into some of the legal aspects of what I'm talking about with that in terms of the undue burden, of which there never seems to be one that is undue, and that Justice Blackmun, who wrote Roe v. Wade, was trying to do the right thing, but the law he had to base it on did not give him an immediate way of basing the ruling on women's rights, and so therefore privacy became the basis. Privacy has never been, although it is important, it never will be a strong enough moral or legal precedent to enable women to have what women really deserve, which is human and civil rights to make their own child-bearing decisions without intervention. Oscar Wilde once said, everything in the world is about sex except sex, which is about power. And nowhere is this more true than in the area of reproductive rights. And so what I want to just kind of do is to say that the pluses in Roe are that it was certainly at the time, and for the time, a huge leap forward for women. There's no question about that. That there was an attempt to strike a careful compromise, and that in and of itself is probably a part of its demise and its weakness, to balance competing ethical and legal interests. Privacy is not unimportant. It is important. And it was probably the best decision that could be arrived at the time, given that Griswold, which preceded it, that legalized contraception was based on the right to privacy, and so that's kind of all they had. The court hadn't really been ruling on women's rights issues at the time of Griswold. The minuses are that those very victories actually sowed the seeds of its imminent, or of its own demise, I would say. It's not gone yet, but there's not a whole lot of it left. Because it was not grounded in women's moral and basic human rights to their own childbearing decisions, there's always a way to kind of move it backwards it's never going to be deemed an absolute based on the right to privacy. And paradoxically, those very personal decisions to make childbearing choices, which supposedly were decided under the right to privacy, ultimately became the most public political battles that we have ever had. I mean, that's the great irony in all of the result of it. I would say that also as a movement, that what happened after Roe was decided is that as a movement we sort of suffered the wages of winning. And with social movements, when you win too much, it feels like you kind of just move on and do other things. And a lot of that, I think, has been a part of the problem. And so, like water on porous stone, what we've had is this constant erosion. And that's where we are today. But ever the optimist, I think it can be turned around.
Well, let's talk about what's happened to Roe. When I started volunteering in 1989 and 1990, we all feared this case called Planned Parenthood v. Casey. There was another case called Webster that had come out where we had barely survived. And then in 1992, we all thought that Roe was going to be overturned and the whole thing thrown out by a much more conservative Supreme Court, and that was in the Casey decision. Now, I know my friend Mr. Rosenfeld here knows all about the Casey decision. What happened with Casey, Larry?
Well, what happened with Casey is that the comfort and security that Gloria referred to seemed to vanish overnight in several respects. As Leon mentioned, the Roe decision seemed to guarantee that during the first trimester, by the way, there really aren't 3 trimesters anymore, it's pre-viability and post-viability. But during what was then the first trimester, that the right to make the reproductive choice to terminate a pregnancy was pretty much sacrosanct, and the state would become more and more involved in the second, and then completely regulated, if not prohibited in the third, with the health and life exception. Casey changed that in significant ways. Essentially, Casey was a case that developed as a result of a Pennsylvania statute or series of statutes that restricted or imposed conditions on the obtaining of a pre-viability abortion. And the court was faced with the question of item by item, restriction by restriction, attempting to determine which passed constitutional muster and which didn't. And I'll talk in a moment about which did and which didn't. But in reaching the opinion in the case, we found we were living in a different world after we had concluded reading that opinion. Because what happened in Casey is there was no majority opinion, there was a plurality opinion authored by Justice O'Connor, which developed a brand new standard that I think has already been alluded here today, the undue burden standard. And the undue burden standard essentially said this: the restriction on abortion rights will violate due process if it places, and I'll use the term, but I'm going to go further, an undue burden on the exercise of a woman's fundamental right to make reproductive choices. So how is that term defined? Well, the court said this, I'll quote this: an undue burden exists, and therefore a provision of law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. So now we had a circumstance where there were restrictions that could be imposed that under Roe we would think could not have been imposed in the pre-viability stage of pregnancy. The court then applied that standard to the specific provisions of the statute before it, and I'll just focus on the 4 most significant. There was an informed consent requirement that was upheld. There was a parental notification and consent requirement that was upheld. There was a 24-hour waiting period provision that was upheld. The one significant provision that was not upheld was a spousal consent requirement, and those have never been successfully promulgated. So there are a couple of things to bear in mind when we talk about undue burden, when we're litigating undue burden. Let me just say now, as a preface to perhaps something we'll get in later, that Gloria is entirely correct, that nowadays nothing seems to be an undue burden, and I'm litigating a case right now where that seems to be the case. And I may get into that if time permits later. But when we're talking about the undue burden, the 2 things to bear in mind, or 2 of the most important things to bear in mind, is that what the court said is that in determining whether a law imposes such a burden, that is, whether there is a substantial obstacle, that obstacle must affect what the court called a large fraction of women within the group affected by the restriction. This is often a central battleground in litigation over the constitutionality or lack thereof of abortion restrictions. And you'll find nobody knows what large fraction means. Nobody knows exactly in a given case what the effective group is. Is it all pregnant women? Is it a subset? Is it even a smaller subset? So that's an area of contention. And the second area is, what is a large fraction? There are cases that say 10% is a large fraction. There are cases that say, no, 20% is a large fraction. These cases are all over the map. They make litigating in this area highly unpredictable. But that's one of the things that Casey did that has promulgated lots of legislation and lots of, therefore, litigation. The second thing, real quickly, is that the court said, the Casey court said that a provision will be invalid if its purpose or effect in the disjunctive is to create these substantial obstacles. Most of the litigated cases tend to focus on effect and not purpose because it's hard to show what the purpose of the legislature is, although I think a lot of us, and I don't think this is cynical at all, a lot of us know what the purpose is. And again, if we can get into the case that I'm litigating now, you find that the courts have tended to focus, and maybe because the parties have focused more on the effect. What is the effect? What burdens or obstacles has it created? As opposed to what was the purpose of the legislature? Was it a legitimate purpose? Was it a pretextual purpose? I think the purpose portion of that disjunctive test is going to come into sharper focus as the legislature has become more blatant, if I might say that, in trying to get these laws passed and upheld.
So let me interrupt you there. Sure. and talking about the purpose. We say we know what the purpose is. Hasn't the other side become very, very adept at recasting the purpose in a way that they think the court will like?
Yes, the answer to that is definitely yes. And Justice O'Connor was wrong, Gloria. So what legislatures have done, the legislature of this great state not accepted from this, is that they have made legislative findings. The legislative findings are often supported by what I would call an outlier position or an outdated study or flawed scientific research. But it's all they need. They just need something to put in the legislative history of the promulgation of the law to justify the fact that it is a health and safety measure. And very often the courts will blindly follow that.
Let me ask Bryan Howard, if you can, Bryan, can you describe for the folks here what the types of laws you've seen, the types of legislation that you've seen recently, over the years, what's going on now? What are the avenues of challenge that the other side are taking on these issues?
Sure. Thank you, Leon. I'm not going to speak with anywhere near the precision of Larry or the eloquence of Gloria, just because I don't. And by way of background, I'm barely an economist. I'm not a lawyer, but my education was in economics before I came to Planned Parenthood. So I'm seeing these restrictions and seeing these initiatives on the part of the opposition through the lens of a healthcare delivery network, but also through sort of the lens of the rationality that's imposed on you by economic study. And I'm going to describe 5 different categories of legislation and initiatives that have been introduced to limit access to abortion care, or that affect abortion care. But in reflecting on Leon and Gloria's comments and this idea of purpose, because we do know it is possible to have a rational conversation about how to regulate healthcare. And indeed, in 2000, when Planned Parenthood Arizona, at that time Planned Parenthood Central Arizona, when the state was considering whether to introduce a specific license for abortion clinics to address a loophole or a gap that had existed in the licensing infrastructure in the state of Arizona, Planned Parenthood brought forward our protocol for the provision of surgical abortion. And that protocol became the basis for the legislation to license abortion providing health centers. It's possible to have that conversation. It's possible to do that work. That's not what we're seeing today. And I was just looking at the history of Americans United for Life, sort of the source of a lot of the model legislation that we see around the country. And it's very interesting that they say at the outset that their goal is the legal protection of human life from conception to natural death, as well as that all unborn children are welcomed in life and protected in law. But then they go on to, and they go on to say that they began to work strategically with state legislators to craft legislation that further restricted abortion but would survive judicial scrutiny. However, they then go on to say that that they wanted to couch the work that they were doing increasingly pursuing state legislation and legal arguments that focused on protecting women from abortion's harms. That the legislation increasingly was about protecting women, and they were completely sidestepping the debate about their intended aim, which was the protection of the unborn, of the pregnancy in relation to the rights of the woman. That being said, let me quickly describe 5 categories of legislation and rulemaking that and ballot initiatives that we've seen. And there are 5 of them. The first is, and I'll just tell you what the categories are, and then I'll give you some examples of what falls into them. The first one that I'm going to describe is our explicit bans on abortion. The second are initiatives to stigmatize either the procedure or to stigmatize women who choose to have abortion. The third are initiatives or legislation to limit access. The fourth is a category of laws that are really about debilitating the providers of abortion care. And the fifth that I added since we put together the outline are initiatives to confer personhood on fetuses. So within the first category, you're having to do with explicit bans. So some examples of those are the so-called partial birth ban, which banned a specific method of performing an abortion, although medically there is no medical procedure called partial birth abortion, but it was, for public relations purposes, a great way of framing a medical procedure and legalizing it. Other examples are the legislation passed in 2012 here in Arizona to ban abortion at and after 20 weeks. If you go back to the observation that the dividing line used to be 28 weeks, and that tried to move it up to 20. That has since been found unconstitutional, and the U.S. Supreme Court has refused to hear a challenge to that conclusion that it was unconstitutional. And then a third category are bans on abortion for certain purposes, including women who are purported to be seeking an abortion based on either the gender of their pregnancy or the race of their pregnancy. The second category was to stigmatize the procedure and women who use it. Some examples of that are legislation that asserts the dangers of the procedure through a lot of micro-regulation, to assert the existence of side effects, including things like breast cancer, that are not substantiated by any mainstream medical authority, but are asserted in the fact-finding in the legislative process. Legislation that questions women's motives, for example, those race and sex selection bans, that women are solely having an abortion because they don't like the gender of the pregnancy. Legislation that questions women's decision-making competence, and this goes all to the 24 and now 72-hour waiting periods. So if you're sitting in this room and you think about any medical decision that you want to make or that you've recently made, imagine being told that you are not smart enough and you have not thought that decision through enough to actually make that decision at that point in time. You will have to sort of check in, a clock starts ticking, and then 24 hours later you're allowed to make your decision.
At some point I'm I'm very anxious to question Gloria about, why she doesn't just agree with that.
Well, on the floor of the State Senate, Frank Antinori said in the informed consent, so-called informed consent legislative proceedings, that the state of Arizona had to protect her sisters and daughters from making decisions that they would later regret. That's what he said was the purpose of the legislation.
And Brian, am I correct that in, I think it's either Kansas or South Dakota, that there's a 72-hour waiting period that doesn't include weekends or holidays?
Didn't know about the weekends and holidays, but...
I do.
Okay.
Apparently women can't think on the weekends or holidays either.
I try not to.
No.
Really quickly, the three other categories. Legislation that limits access. So for example, for over a decade, nurse practitioners in the state of Arizona were able to dispense the medication that initiates the termination of a pregnancy, what used to be known as RU46, and today goes by the name of mifepristone. For over a decade, nurse practitioners and physician's assistants in Arizona were able to dispense that medication. The state legislature decided that for women's health, that these medical professionals would no longer be able to provide that care. That care had been available in a number of rural communities across the state because there were nurse practitioners who were willing to dispense the medication. The minute that nurse practitioners were banned from dispensing the drug, women in all rural Arizona women lost access because those were the only providers who were able to dispense the medication and willing to dispense the medication. So the only place that abortion was available after that was in Phoenix and Tucson.
Brian, it's probably worth mentioning that the reason the legislature advanced that is because a Planned Parenthood nurse practitioner had a complaint filed against her with the nursing board. And the nursing board was then faced with the question of whether providing medication abortions as a nurse practitioner was within the scope of practice. And the nursing board said it is within the scope of practice. And the legislature immediately turned around and said, no, it's not. So we have the legislature overruling the body that is charged with the responsibility of regulating the practice of nurses in the state of Arizona.
Not only did the legislature say that take away or to override that decision, but they also said that going forward, the Board of Nursing, which is the regulatory authority for scope of practice for all classes of nurses in the state of Arizona, it took away the authority of the Board of Nursing to regulate anything related to abortion. So they said, you get to regulate nurses in every other category of women's health, but we, the legislature, know more about women's health than you, the Board of Nursing. The last couple of categories are initiatives to debilitate providers and the defenders of patient care, efforts to defund Planned Parenthood. In 2012, there was an initiative or a piece of state legislation to prevent abortion-providing health centers from seeing poor patients who were insured by Medicaid, with the thinking that that would interrupt a funding stream for Planned Parenthood and other abortion-providing providers. And then the last category is this idea of personhood, and it's come in many forms. Sometimes it comes in the form of enhancing criminal penalties for women who miscarry, or in the event that a woman miscarries as the result of she's a victim of a crime. In the process, she miscarries. Under these laws, the perpetrator of the crime could be charged with homicide toward the fetus and creating legal protection for the fetus, even if the woman herself didn't. It becomes a separate crime to create legal protections for the fetus, and that has gone a step further, where a number of states have state voters have voted on initiatives to actually confer constitutional personhood on fetuses from the moment of conception. So in other words, all of the rights enumerated in the state of Arizona Constitution would be conferred on first one cell, and then two, and then four, and then so on. And obviously when you think about that, you then have the competing interests of the constitutional rights of the fetus versus the constitutional rights of the woman. That was much too much, sorry.
No, thank you.
Just because our state's productive.
Well, where, and I'll ask the panelists, I mean, where do the current challenges that we see that would be, you would call rights of conscience? Gloria?
Can I just say something?
Oh,
I'm kind of crawling out of my skin here because I am also not a lawyer, but I rest my case. This is not about abortion. It is not about health. It is not about any of those things. It is about whether women will have an equal place in our society. And until we are willing to stand up and say that, we're going to keep on being pushed back and pushed back and pushed back and pushed back. And just to sit here and list all of these things that are happening, it just points that up. The whole federal abortion ban case, and I actually extend this to the refusal clauses. I mean, I will not call them rights of conscience, but there is a parable in them, and the parable is that they are all created in order to do exactly what all of you law students learn in probably your very first courses, which is that whoever defines the debate generally wins it, right? And so that's why they are developed, and that is the fallacy in fighting back against them, is that until you are fighting forward and not fighting back, you just will keep getting pushed back and pushed back and pushed back, and there will be yet a longer list next year. I mean, when you look at how the federal abortion bans came about, they literally, I wrote about this in the War on Choice, they literally were created in the office of a member of Congress with some anti-choice advocates in the room, and they came up with the name of it, and they totally they created it out of whole cloth. And it occurred because of an unholy political alliance between the right wing and the Republican Party, and I would have to say, very often the lack of passionate action by the Democratic Party, and to not allow these things to happen. And so it's really a political battle, and the political battle is about how the issue gets framed. And until we're willing to stand up and say, excuse me, but women are persons, women are human beings, women have human and civil rights. This is Equal Pay Day, by the way. You know, it's a good day to be talking about the equal rights of women. We'll have another panel next year and the next year and the next year, and it's not going to be done.
Hold you to that.
Okay.
All right.
Larry.
And so that brings us to the Hobby Lobby case. Are you both pretty much familiar with Hobby Lobby? Gloria says this is all political. Well, it is all political because the Supreme Court is so politicized that whoever has appointed the larger share of the justices is going to prevail on these issues. That's just a fact. So here we have the Hobby Lobby case, which raises the question of whether a for-profit entity that's neither a house of worship nor an entity whose purpose is principally religious, unless the religious practice of Hobby Lobby is to have religion as your hobby, which it isn't. Can those for-profit private entities nonetheless assert a freedom of religion claim, which historically has only been viewed as a personal right and not a corporate right? And the focus on this, in this case, is on the Religious Freedom Restoration Act, which was passed, I think, in 92, 93. And it's an act that says it prohibits the enactment of laws that substantially burden a person's free exercise of religion. Well, Mitt Romney famously said corporations are people. And we laughed. And then came the Citizens United case, which was a free speech case, where the Supreme Court 5-4 said corporations are people for free speech purposes, and struck down some of the campaign funding restrictions. We're probably looking at the same 5-4 split on the court that we had in Citizens United in Hobby Lobby, which means, and Hobby Lobby, of course, came up in the context of the so-called contraceptive mandate. It's not really a mandate because you can pay a penalty and opt out of the mandate. but it arose in the context of the Affordable Care Act, which I don't call Obamacare, Affordable Care Act's requirement that employer health plans include contraceptive coverage. If the court agrees with Hobby Lobby, think about the ramifications regarding abortion rights. I'll call it conscience laws, sorry, Gloria, but that's sort of what they're called in the state laws, and I don't agree with it either, but that's what they're called. So currently a conscience clause in a state, that a state has an act that says if you as a pharmacist have a religious objection, you have a fundamental or strongly held or legitimately held, they're all phrased differently, religious belief that says you cannot support or assist or facilitate someone in obtaining an abortion, you can opt out of prescribing medication that would help that woman terminate the pregnancy. Hobby Lobby is a huge company. It's all over the country. Think about a pharmacy that is all over the country with stores all over the place, whose owners, principals, I don't know how we're going to define who gets to make these decisions at the corporate level, but as in Hobby Lobby, let's assume this pharmacy chain decides that we, as a person, have a fundamental religious belief against facilitating abortion. We don't really care if individual pharmacists who work in our store don't have that difficulty or that opposition or that fundamental belief that abortion is, as a matter of religion, wrong. We don't care. We, as a national pharmacy chain, will no longer facilitate the performance of abortion, and we will no longer allow any of our pharmacists to prescribe. That's sort of the kind of thing we're facing if Hobby Lobby comes down the way I fear it's going to.
Okay, now we had some problems with the lunch delivery, so we're being cut a little bit short, but before we ended, I did want to ask, I wanted to give each of the panel members the opportunity to address one final question, however briefly that has to be. And I'll start with Gloria. What can these people here do? What can these young law students, these people who are here, what can they do to make this better as we go forward?
Well, I want to just jump on to what Larry was just talking about, which is we need to remember that that case is about contraception. It's not even about abortion. So for all of the times that we have said and people have kind of rolled their eyes, this is not about abortion. It really is about whether women will have autonomy and moral autonomy and legal autonomy over their own bodies and equal rights and personhood. Believe it, when there are people who really even don't even want women to have the ability to prevent unintended pregnancy. That makes it pretty clear. And so therefore, to me, the only answer I can give you, Leon, is that, or to give all of you, is to say that what I hope you will do is not spend a whole lot of time, although certainly you have to try to fight back against these bad things, and we have to put some energy into that. But I would strongly suggest that you put at least 80% of your energy into writing legislation that will affirm a woman's right to reproductive self-determination, writing legislation that will declare that conscience inures to all of us, that we all have rights of conscience, and therefore, you can't stop pharmacists who you just completely recast the whole thing. I bet you that with all these wise minds here, you all could get together this very afternoon and come up with at least 200 possible pieces of legislation or policy initiatives that we could start moving forward tomorrow. And that's really what needs to happen so that you all are defining the terms of the debate, not the other guys.
Bryan Howard?
So I'm going to switch hats for a second and speak as president of Planned Parenthood Advocates of Arizona, which is a voter education group.
We'll convene the C4 event right now.
I work for both, so I get to wear this hat now. So wherever, I'm going to get to something much more pedestrian. Wherever you are currently registered to vote, and I dearly hope every single one of you in this room who is legally eligible is registered to vote, wherever you are registered to vote, it can't possibly be as bad as it is in Arizona. Re-register here in Arizona, number one. Number two, I think that the framing that Leon and Larry and very much Gloria has described, I mean, I love the quote about everything is about about sex except sex, which is about power. I mean, this is about women, and this is about their autonomy, their ability to make their own decisions in their own best interests without this odd societal misogyny overlay that permeates our country even amongst the best of us. And it boils down to raw power, and who is sitting on the 9th floor of the executive tower, who is the governor of the state of Arizona, who is the Secretary of State who governs, who oversees voting rights and the ability to vote, who is the Attorney General who is defending the laws or making decisions about whether the laws are constitutional and should be defended. You need to be engaged in that process. We saw what happens with SB 1062 about 6 weeks ago, when enough voices said that it was simply unconscionable that the state of Arizona would sanction the ability of, what that law basically said was any individual corporation, foundation, nonprofit that did not want to abide by a state law didn't have to if the state law violated their sincerely held religious beliefs. That's not the society we live in. We live in a society of laws that protect the strongest amongst us and the weakest amongst us, and the only way that is going to remain the case in the state is if you're engaged in the political process. So, re-register and vote.
And think about running for office at some time in your life. You're going to live a long time, you'll have plenty of time to do it, you run for something at some point.
I will run you today.
Larry, real quickly, there's 3 branches of state government, 3 branches of federal government. In Arizona, when our governor, Democratic governor, vetoed all of this legislation, left, all hell broke loose. All hell could break loose at the federal level too if we're not careful. Think about that when you do all of the things that Bryan and Gloria mentioned.
All right, well, thank you. I'm going to turn it over to Cory.
Thank you all for coming. I'd like to thank our panelists, Gloria, Bryan, Larry, and Leon. Thank you very much for your time today.
That's it.
And with that, I'd like to invite you to leave.